This is a discussion about California courts and the reenactment rule. In the county of San Diego versus the Commission on State Mandates in 2018, our California Supreme Court dealt with the Sexually Violent Predators Act, which, among many other provisions, imposed certain duties on county governments. The court also addressed in its decision the California Constitution's reenactment rule. Here, the Constitution requires in Article 4, Section 9, that a section of a statute may not be amended unless the section is reenacted as amended. The Supreme Court granted the state respondent's petition for review to consider whether Prop 83, by amending and reenacting provisions of the SVPA, constituted a subsequent change in the law sufficient to modify the Commission on State Mandates' prior decision, which directed the state of California to reimburse local governments for the cost of implementing this act. In this decision, the Supreme Court explained that when an existing statutory section is amended, even in the tiniest part, the state constitution requires the entire section to be reenacted as amended. The effect of this section, the court said in Yoshisato versus Superior Court in 1992, is that voters considering an initiative that seeks to make discrete amendments to selected provisions of an existing statute are forced to reenact the entire statute as amended in order to accomplish the desired amendments. The court went on to cite the rationale for compelling reenactment of an entire statutory section when only a part is being amended is to avoid the enactment of statutes in terms so blind that legislators themselves were sometimes deceived in regard to their effect, and that the risk that the public, from the difficulty of making the necessary examination and comparison, failed to become apprised of the changes made in the laws. This cites all the way back to an 1896 decision in Hellman versus Shalters, California Supreme Court. So they went on to say, subsequently, a substantial part of almost any statutory initiative will include a restatement of existing provisions with only minor non-substantive changes or no changes at all. Prop 83 is an example. It reenacted verbatim Subdivision I of Welfare and Institutions Code Section 6601, which the Commission's 1998 ruling had identified as the source of local government duties. The initiative made changes to individual subdivision of the Welfare and Institutions Code, but the minor changes to the procedures governing the filing of a petition for conditional release had no effect on those mandated duties. The court said, "We conclude that the Commission's approach is at odds with the constitutional requirement that the state reimburse local governments for the cost of complying with state mandates. If the term ballot measure in Government Code Section 17556 were defined as automatically including every provision subject to constitutionally compelled restatement in an initiative, it would sweep in vast swaths of the California Code." They said later that according pivotal significance to a mere technical restatement also would prove difficult to reconcile with Government Code Section 9605. What this statute provides is that where a section or part of a section is amended, it is not to be considered as having been repealed and reenacted in the amended form. The portions which are not altered are to be considered as having been the law from the time when they were enacted. The new provisions are to be considered as having been enacted at the time of amendment. So this court decision makes clear that the Constitution's reenactment rule applies regardless of wholesale changes or minor technical amendments to statutory language. This ensures that both legislators and the general public can see in context what changes are being made to fully understand how these provisions will apply to an existing statute.